Hi guys, so we are now back. We are going to be doing some of the reply memorandum from Jen Abel to um, Jonesworks opposition for her motion for conditional summary judgment. We'll have a look as well at I'm not going to go into detail, but she has replied to Jonesworks opposition to her Rule 56.1 statements, and some of them are quite funny, so we'll just quickly flick through a few of them. The vast majority of the Jonesworks Jen Abel ones are quite boring and mundane, but there is a couple of interesting and hilarious ones. All right, let's look at the reply memorandum. This is really quite short, actually, so it's only 15 pages, and some of that isn't even actual it's like the contents and the indexes and stuff. Okay. Hold on, let me just increase the size. All right. Regardless of how Stephanie Jones tries to minimize her role, Jonesworks cannot sidestep that A. Jonesworks was contractually obligated to perform public relations services for the Wayfarer clients. B. Jonesworks employed Abel as its vice president of talent and as the point person for the Wayfarer clients. C. Jones knew of Abel's activities that are the subject of Lively's claims. And D. Jonesworks was handsomely paid by the Wayfarer clients for the work Abel performed for them without any commission being paid to Abel, as is standard. Okay, let's have a look. Is there a footnote? Defined terms not defined herein have the same meaning as in or Abel's brief dated November 11th. Okay. Jonesworks' assertion that it maintains an ethos of positive publicity is refuted by her former employees. And in her own words. And they've referred to the Glassdoor reviews. Remember the ones I did a video? They referred to Glassdoor. Many reviews highlight a challenging management style, particularly involving the CEO, Stephanie Jones. The feedback describes a toxic and controlling atmosphere with verbal abuse and high turnover and a lack of HR support. Okay. Right. In June 2024, Stephanie Jones instructed Jonesworks staff to redacted about Lively, and the staff confirmed for Jones that they would redacted. Jones testified redacted and that Jonesworks would do redacted. Ultimately, Jones did whatever Lively needed her to do. Betray her own clients, making Jones the double agent. And foolishly increasing Jonesworks' own potential liability. Jonesworks' opposition ignores Lively's verified interrogatory responses in which Lively identified the specific actions, emails, and text messages that formed the basis of her claims against Abel. Citing Lively's sworn responses, Abel's motion demonstrates that her actions consist of monitoring negative publicity of Baldoni and potentially garnering public publicity for him, actions that fall within the scope of Abel's employment. Jonesworks does not cite any evidence, because there is none, showing that Abel placed, boosted, or amplified any negative content about Lively. Instead, Jonesworks A. inadequately hinges its opposition on conclusory allegations from Lively's second amended complaint that Abel participated in a sophisticated press and digital campaign designed to retaliate against Lively, and B. then contends that the scope of Abel's employment did not include such retaliatory activity. However, Jonesworks cannot defeat a motion for summary judgment by resting solely on pleadings because uncorroborated allegations are insufficient to create a triable issue of fact. Furthermore, Jonesworks was aware in real time of Abel's public relations activities because Jones was surreptitiously monitoring Abel's phone, as evidenced by text messages involving Abel, but no other Jones employee, and produced herein by Jonesworks. Yeah. Highlighting its desperation, Jonesworks mischaracterizes the defendant's expert report to provide an opinion which it unambiguously does not. Specifically citing the expert's report reference to Lively's allegation that a retaliatory smear campaign is not standard public relations, Jonesworks disingenuously contends that the expert concluded that Abel's actions were not ordinary public relations. In other words, even though the expert clearly refers to Lively's claims and what is alleged in her second amended complaint, Jonesworks misrepresents that such statements are the expert's opinions. In any event, Jonesworks has now opened the door and waived any objection to the admissibility of the expert report. As such, the court should consider the expert's unrebutted opinions that the steps outlined for the Wayfarer clients in the scenario planning document, so heavily relied upon by Lively, are consistent with standard reactive crisis management practices, and that any artificial proactive campaign to discredit Lively would have taken weeks or months to effectuate, not mere days, as she alleges. Oh, is that what the expert is saying? Wow. Okay. Argument. The record demonstrates that Jonesworks should indemnify Abel. Abel acted within the scope of her employment for Jonesworks. Okay, in determining whether an employee's tortious acts have been committed within the scope of his or her employment, the court weighs the following factors: the connection between the time, place, and occasion for the act, the history of the relationship between employer and employee as spelled out in actual practice, whether the act is one commonly done by such an employee, the extent of departure from normal methods of performance, and whether the specific act was one that the employer could reasonably have anticipated. Okay. Whereas here no conflicting evidence exists as to the essential facts, a court may make a determination as a matter of law. Jonesworks admits that it is a well-known public relations firm, that it hired Abel in 2020, and that it later promoted her to Vice President of Talent. Abel served this role from November 2021 through August 21st, 2024. The conduct at issue in Lively's claims occurred between the end of July 2024 and in the middle of August 2024. Jonesworks admits that during such period, Abel redacted. Abel performed public relations services for the Wayfarer clients, and Abel served as the primary point person for Wayfarer and Baldoni. Jonesworks acknowledges that under the terms of its Wayfarer agreement, the Wayfarer clients retained Jonesworks as its exclusive public relations counsel to provide strategic communications services. Among other things, Jonesworks agreed to assist in developing, writing, and updating communication materials related to all press outreach, manage media and press communications, advise on any marketing and campaign strategies to ensure the strongest press angles are aligned, conduct media monitoring and competitor tracking for industry press, and create monthly clipbooks and activity reports that detail media impressions. According to Jones, Jonesworks would do redacted. The services provided by Jonesworks were redacted. Jonesworks assisted Baldoni with redacted and redacted. In exchange for these services, including the work performed by Abel, the Wayfarer clients paid Jonesworks redacted per month, payments which continued throughout the relevant time period. Jonesworks does not dispute that A. Abel advised Jones of redacted. B. Abel managed media and press communications for the Wayfarer clients. And C. Abel communicated with Jonesworks personnel about redacted and TikTok videos. Jonesworks also concedes that Jones knew that Abel was working with Baldoni on his press tour in connection with the premiere of the film in late July, early August 2024, amid reports of strife between Baldoni and Lively. Furthermore, Jonesworks admits that Abel kept her in the loop for all press strategy. During this period, Jones assured Baldoni that she had a plan and that she had redacted. Jones also notified Baldoni that redacted. Jonesworks admits Jones took credit for successfully managing every crisis for Justin without any negative press coming to light. Jones further provided the Wayfarer clients with a strategy for dealing with the redacted, which included redacted and make redacted. Contrary to Jonesworks' theory that Abel went rogue, Jones's own emails show that she had assigned multiple employees, Team Baldoni, to work on the Wayfarer client's account during summer of 2024. Jonesworks' reliance on allegations in Lively's pleadings is misplaced. In response to a motion for summary judgment, the non-moving party cannot simply rest on conclusory allegations made in a pleading. To defeat a motion for summary judgment, the non-moving party must point to evidence in the record demonstrating whether the existence of a material, triable issue of fact or that summary judgment is inappropriate as a matter of law. Here, Jonesworks insufficiently cites the conclusory allegations from Lively's pleading as proof that Abel's actions fell outside the scope of her employment. Jonesworks fails to discuss the evidence cited in Lively's interrogatory responses, which evidence Abel addresses in her motion, and which evidence proves that Abel's public relations activities were within the scope of her employment. Indeed, the case law cited by Jonesworks belies its argument, acknowledging that in opposing a motion for summary judgment, the non-moving party may not rely on unsupported assertions, conjecture, or speculation, and that to defeat summary judgment, the non-moving party must set forth significant probative evidence on which a reasonable fact finder would decide in its favour. Okay. The expert report supports the motion. Jonesworks tries to misdirect the court by contending the expert report of James Hegarty undermines the summary judgment notion. Specifically, Jonesworks cites the expert report's summary of Lively's allegations, and then Jonesworks misrepresents that such recitation constitutes the expert's opinion. Now that Jonesworks has opened the door, the court should consider the unrebutted findings of the expert report. As explained in the expert report, the scope of work agreement prepared by TAG and the subsequent scenario planning document are in keeping with standard practice in the crisis communications field as evidence of reactive crisis planning. Notably, the scope of work confirms that TAG will work closely with Jonesworks. And I said that too. Like Jones was saying, oh, well, Abel was working and deliberately shutting out Jones. But the scope of work document from TAG mentioned several times over that TAG will work closely closely with Jonesworks, will align with Jonesworks, etc., etc. There was like, a document. They're citing one document saying it made no mention of Jones, but it also made no mention of Abel, of Nathan, of of Wayfarer in general. And then they ignored another document which specifically at several points said we will work with Jonesworks. So very selective. Okay. Mr. Haggerty also opined the hiring of a crisis communications consultant in the face of perceived reputational threats should not be considered in any way evidence of a negative or nefarious intent. Rather, it is well established that such retention is entirely acceptable, appropriate, and prudent for organizations, brands, personnel, or corporate and high-profile individuals seeking to mitigate reputational risk, particularly in the face of threats. Footnote, Mr. Haggerty also states that the social manipulation plan alleged by Lively could not have been implemented merely within days, as she alleges, which, again, that's the point we've made as well. Jed Wallace has also made that in his Texas filings. Like, he was brought on and he managed to change the entire world's opinion of Blake Lively in just a couple of days. Nope, impossible. The expert says the growth in media and social media coverage negative to Ms. Lively starting in August 2024 is unlikely to have been caused by the work done by the crisis communications consultants hired by the Wayfarer parties, given the short time frame. In short, the expert report confirms that Abel's activities were standard public relations steps and fall squarely within the scope of her employment. Abel's public relations actions were foreseeable. Jonesworks further argues that it did not foresee the conduct at issue and/or the conduct was not a natural incident of Abel's employment. However, Jonesworks neither specifically addresses the conduct identified by Lively in her interrogatory responses, nor cites any evidence demonstrating that such conduct was unforeseeable or not a natural incident of Abel's employment. The record demonstrates that Abel's conduct was not only foreseeable, but also that Jones played an integral role therein. In fact, when Jones was notified about growing tension between Lively and Baldoni, Jones told her team, including Abel, that they would redact it and directed her team to redact it about Lively. Jonesworks personnel responded to Jones's instructions stating redacted. Jones then redacted her team. Stated differently, Jones instructed Jonesworks employees to redact it. I look forward to that being unredacted. Jonesworks seemingly argues that the basic public relations work responding to press inquiries, monitoring media coverage, and coordinating messaging is beyond the scope of Abel's employment. Specifically, Jones claims Abel planted a negative story, which Jonesworks concedes via silence was never published. And in any event, placing stories is standard public relations. Identified social media content that was hostile to Lively, which Jones expressly redacted. Suppressed a report of Baldoni's alleged misconduct, standard public relations, and worked with TAG to manipulate content without citing evidence any manipulation occurred, let alone by Abel. In sum, according to Jonesworks, the very work that Jonesworks contracted to do for the Wayfarer clients and which the expert report confirms is standard public relations activities are beyond the scope of Abel's employment. The court can and should reject that notion without a trial. Jonesworks has taken a proper skewering in this document. Jonesworks identifies no post-date conduct warranting any limitation of Abel's motion for conditional summary judgment. Jonesworks argues that summary judgment is unavailable for Abel's post-termination conduct. However, Jonesworks does not identify any such post-termination conduct. Instead, Jonesworks meekly refers to Lively's allegation that the so-called retaliation is ongoing. At most, Lively's interrogatory responses state that Abel redacted. Jonesworks does not explain how that is actionable. Jonesworks improper Rule 56.1 response. Federal Rules of Civil Procedure 56C1A requires a party opposing a summary judgment motion to cite particular facts in the record in order to demonstrate that a genuine issue of material fact exists for trial. Each of these responses must be followed by a citation to evidence which would be admissible as required by Federal Rule Civil Procedure 56C. Otherwise, it will be deemed admitted for the purposes of the motion. The purpose of Local Rule 56.1 is to streamline the consideration of summary judgment motions by freeing district courts from the need to hunt through voluminous records without guidance from the parties. Courts routinely reject conclusory non-responsive answers and objections that simply advocate for a different spin on otherwise uncontroverted facts. Jonesworks Rule 56.1 response and counterstatement is a 64-page smokescreen littered with improper qualifications or uncontested facts, feigned, disputed, or partially disputed. Facts without any contrary support, improper argument, and newly asserted facts irrelevant to Abel's motion. Oh, excuse me, sorry. Right. In response to certain facts it cannot dispute, Jonesworks tries to limit his response by writing, for instance, undisputed as to the content of Jones's referenced testimony. In other instances, Jonesworks attaches long narratives of irrelevant information and argument to paragraphs it should otherwise admit. For example, in response to Abel's assertion that the Wayfarer clients from May 2020 to August 2024 paid fees to Jonesworks, Jonesworks responds undisputed, but then launches into a 10-line response seeking to inject its own spin on an incontrovertible fact. These transparent attempts to obfuscate Abel's factual assertions, as in page after page of argument, are improper. Which is part of the reason why I'm not going to be reading the vast majority of the Jonesworks Abel Rule 56.1. It is incredibly boring. It's also improper. Okay. Just going to read this citation as well. In Hayden, this is Judge Lyman they're quoting. To the extent that plaintiff has made assertions that are improper, for example, if they lack support in inadmissible evidence, advance improper legal argument or conclusory assertions, or are otherwise immaterial, the court will disregard such statements. Jonesworks also purports to cite evidence that does not actually controvert Abel's assertions. Again, they're using Caro, they're citing Lyman. Assertions that certain facts are disputed without citation to admissible evidence need not be and are not accepted by this court. Then there's a case of Ball, again Lyman. Deeming admitted facts plaintiff failed to properly dispute. And this is what I've said this before, right? Wayfarer have taken to making a point of citing as many Lyman cases and judgments as possible, because I believe that they are aware of how lively leaning his decisions are. So they are now thrown in, whereas they might have done one or two decisions before, now they are throwing in as many cases where he has made a judgment that supports their position as possible, because it is much harder to justify someone going against their own decision. Even though his decision is not binding upon himself, it is far more difficult to justify when, there's one judge has taken a decision and then taken a different decision in a case on similar facts and merits. Obviously, when you've got two different judges deciding two different cases which are similar in fact, then there is scope for different opinion and different interpretation. But that is harder to argue when it's the same judge. It's a clever move, it's strategic. Okay, so conclusion: for these reasons, the court should grant Jennifer Abel conditional summary judgment against Jonesworks on the second cause of action in her amended third-party complaint. And I wholeheartedly agree. Now I'm going to give everyone a bit of a laugh. I'm going to say I really love that that they used the Glassdoor reviews. I was praying that someone would put that in somewhere because they're so damning. They are so damning. I have done an X post in my Stephanie Jones deep dive on X where I have used a lot of those Glassdoor reviews, and I've done a video a couple of weeks ago where we went through it. It was hilarious. This is the so this is going to be Jen Abel's response to Jonesworks' counter statements. So obviously, as we saw with the Lively and Wayfarer did their Rule 56.1 statements. Lively then copied and pasted them and then provided a response and then provided a subsequent set of statements of her own. I was expecting, because Jen Abel has done it here with Jonesworks, I was expecting Wayfarer to respond to Lively's when they filed their reply. I cannot see that statement has been filed. I'm not particularly concerned about that myself because they actually I did the video earlier for the Lively reply by Wayfarer, and they actually referred to many of her counter statements and used them in argument in the main reply memorandum. So I don't know why they may have chosen to just not do it. They may have forgotten about it, or maybe I just haven't seen it, but I really can't see the one for Lively. Wayfarer also had to reply to the judgment on the pleadings as well, so it may be that they just didn't have time. I don't know, but it's not there. So if it's not there, I can't cover it, which is why I'm sort of decided, well, I'll cover a couple of things here, but there are some things on here that are actually quite funny. So background. So so this is Jonesworks response statements, and Jen Abel was responding to them. And the first one, Jonesworks is an award-winning PR agency. Sorry, I'll make that bigger. That provides positive, bespoke PR to its clients. Jen Abel disputed. And I had a look at the what they've cited there to support, which is Fritz's declaration. Okay, so we'll just pop to see that. It doesn't tell you much, but I'll walk you through it. So Exhibit 2 of Fritz's declaration. So here is the declaration. And here, point 4, a true and correct copy of Jonesworks is attached as Exhibit 2. That is under seal. Okay, they did file a letter requesting that be sealed. It is a Jonesworks Bates number, so whatever it is that counters the Jonesworks narrative that 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 they are an award-winning PR agency that provide positive, bespoke PR services to its clients was provided by Jonesworks, just to make it even funnier. Okay, so I'm just going to scroll quickly through. I'm going to look for the disputed, but here is one of the responses that fails to comply with the rule 56.1b. I'm not going to go into it, but it's like, the statement was Jonesworks was retained to promote Baldonia's projects, etc., etc. No, this is Jonesworks. Jonesworks was retained to retained to promote Baldoni and his projects through positive publicity, etc., etc. This is one of the statements that Abel flags as improper. Okay. Disputed. This is disputed. The personal publicity that Jonesworks was retained to perform on behalf of Baldoni and Wayfarer did not include any activities contributing or amounting to the digital smear campaign. Abel, Nathan, and others are alleged by Lively to have engaged against Lively on Baldoni's and Wayfarer's behalf. That's disputed. Okay. Okay. As a PR professional with over a decade of experience, Abel understood when she joined Jonesworks that she was employed to engage in proactive, positive press to help build her clients' brand and promote their projects and partnership, and that her duties did not include promoting negative coverage. That's disputed. There's an awful lot that's disputed. Just while I'm kind of looking through this, found out something quite interesting that for several years running, including this year, Quinn Emanuel is voted the most feared law firm. Isn't that interesting? Out of all the law firms that other law firms don't want to have to be going up against, Quinn Emanuel is the number one feared law firm. I just find stuff like that interesting. You'd never know that, though, the way they have been arguing some of this. Now, I have always said that some of the arguments are coherent. They are quite reasonably made. The spoliation sanctions, for instance, when I weighed Jonesworks' opposition to Lively's reply, I thought Jonesworks was the far more superior of arguments. Lively was just a baffling word salad. Jonesworks actually made some reasonably good arguments, and I was quite impressed. I'm not saying it's enough for her to, I'm not kind of giving an opinion on how I think the actual sanctions will be decided. I just thought, in terms of arguments, they kind of did a pretty good job. Almost as good of a job as Wayfarer opposing the sanctions. Whereas in contrast, when you look at Lively's motion and reply brief, they were pretty awful and just nonsensical. I mean, there's something redacted here on May 20th, 2024. Something's redacted. The response is a statement is neither relevant nor material to the outcome of the motion, and therefore no response is necessary. Notwithstanding, undisputed for purposes of this motion only. So I don't know what it is. And that's, again, that kind of response is becoming, it's here again. And pretty much here again, yeah. So I mean, there's another 30 plus pages of this, so I'm not going to go through all of this. I found it hilarious that the outset was to dispute Jonesworks' kind of egotistical description of itself as an award-winning PR firm who do bespoke packages for its PR, positive PR, etc., etc. Right. Okay. I am. What am I doing next? I am doing the. What am I doing next? Wayfarer's reply brief to Lively's opposition for motion on judgment of pleadings. Yes, there we go. So I'm going to do that, and I will be back later.